After the 2023 general elections, or the elections generally, the total number of 1,044 suits have been filed, and this is according to Impact Development Initiative. So this NGO said that a staggering 1,044 suits have been filed last week by the election tribunals across the country, and this was has demonstrated the ugliness of polling and the stunted growth of democracy in the world's most populous black nation. And the dashboard revealed that 470 petitions have been filed against the House of Representatives election, 327 against the State House of Assembly elections, 180 against the senatorial, 62 against the governorship, and 5 against the presidential poll. So based on geopolitical zones now, 301 petitions were filed in the South, 187 in the Southeast, 166 in the Southwest, 149 in the North Central, 124 in the Northwest, and 106 in the Northeast. So the platform also showed that 883 platforms were filled on the grounds of non-compliance and corrupt practices, and 532 were filed against candidates elected without the majority of lawful votes cast. And others are 279 petitions against candidates elected but were not qualified to contest the elections. And then this places a heavy burden on the judiciary to rise its billing as the last hope of the people and the ultimate guardian of justice and the rule of law, and of course democracy. So we have in the studio Salahuddin Hashim. He's a former senior program officer at CISLAC and currently the director of programs Clean Foundation. We also have joining us via Zoom, we have Barrister Sam Kagbo. He's a lawyer and a social commentator. Gentlemen, thank you so much for joining us.
Thank you very much for having me.
All right, so the election petition, 144.
1,000.
1,000, I beg your pardon, 1,044. That's huge, right? What's your take on this?
Well, it's staggering, and I think it has a dual response to the need for citizens to challenge specific procedural issues leading into the elections. And for me, the issue is that our elections are actually governed by specific rules and laws, and that is what makes it unique. And of course, election petitions are also regulated by specific laws, which also makes it quite fundamental in terms of what you bring before the panelists and the bench. But one of the things that I find quite of serious concern is actually the validity of those petitions, because a number of individuals today I've seen going to court and challenging suit as part of procedures to negotiate, and of course using it as a way of also trying to demonstrate relevance. And if you look into all of those 1,044 cases, merits in all of them, because even in law there are ingredients, and I'm sure the learned fellow would be able to run us through that. The ingredients in a lot of them most times suggest that there were issues that sometimes are just a time wasting for the courts, but of course every citizen has that right to be able to approach and of course bring a number of issues in terms of seeking interpretation, where procedural issues are being breached, where issues that borders around qualification are also being undermined, and of course the voting itself and the election day itself, what exactly has happened. So now contestation has moved from the polling units, it has now moved to the judiciary, and there are lots of citizens, there are a lot of expectation from citizens to see what exactly becomes the outcome of the elections. And of course the section 132, I think, subsection 7 and 8 offers very clearly that there must be a regulation about 21 days after results are declared for you to file. So if you are within that time frame, then you are safe. And of course the court has 6 months from the date of the first petition to the time to conclude. So that also time frame was also provided. So we're also expecting that the courts would abide by all of these time frames to be able to allow those who need to take governance to the next level to do so. One thing that we have also noticed is that there is a lot of time wasting elements in all of these procedure in courts, distracting governance and all of that. So I think that these are some of the things that we need to really work around. Maybe if we strengthen the integrity of our judicial system in the future, it probably would further reduce. And in the last, since we returned to the Fourth Republic in 1999, I think the only time we have had a fairly stable post-election tribunals was in 2015 when President Buhari won for the second time. But every other presidential election has been marred with lots of suits, and that for me is something that we really need to work on to be able to reduce this kind of glitches that we find in our elections.
Okay. All right, well, let's go to Sam Kabul, who is joining us virtually, and get your own thoughts around this. What do you make of this number? 1,044 petitions filed so far, arising from the 2023 general elections. In your own, standpoint, is this a plus to our democracy, or is it retrogression?
Well, let me start by saying that it's within the law and it's part of the rule of law. People have the fundamental right to espouse their grievances before the tribunals. So as many of them that come, that tells you the number of them that were agreed by the election. But I listened to the gentleman and I was really impressed with this level of assessment of actually what has transpired and is transpiring before the courts. Why we have this number of cases is simply because of the way the elites, especially those of them that call themselves, I'm sorry to use the word, has gave the impression that the elections were free and fair. And
with Sam Kabul, we'll try to get him back to rejoin the conversation. But I mean, let me come back to Salahuddin. Do you think that this is a product of, the flawed process of our elections, or is this, an indication of people being more aware now or more informed on what they need or their rights as regards processes?
I think basically it is also about the improved legal system that regulates the elections, which for me I find quite interesting. The Electoral Act 2022 is one instrument that even the elites have not had their time to go through, and that is why they run foul of some of the provisions. And I tell you, there will be a lot of interesting outcomes, and that is not to preempt some of the outcomes from the elections, because I tell you, the elites who particularly beneficiaries of didn't take time to go through them. So there are unique provisions that are very interesting aspect that you might want to undermine, but have the capability to turn things around. And of course, for me, the unfortunate part is that even some of the petitioners in court also have some aspects of the laws which they have also contradicted. So for me, it is actually a 360 circle, is a panorama view of the entire conscience of the society, and of course the integrity of the electoral process that this particular interpretation would be looking at. But I think the issue that came out very strongly for me is actually the 25% interpretation, and that is the aspect that citizens would actually be looking out for to find out what exactly would be the determination of the outcome. And for me, again, is the fact that the commercialization and politicization of the judicial process is something that I find very, is a big worry
Exactly,
to me.
because earlier on you mentioned, wasting of the court's time.
Absolutely.
Where we see petitions filed on frivolous grounds. Like, you could even see, for a layman, you could even see how that this matter is. So, for instance, we have a case that was filed by a candidate in the 2019 general elections. Candidate is a Hope Democratic Party now, a presidential candidate, who was seeking that the president-elect should not be inaugurated on May 29 because he claims that he won the 2019 general elections and that the President Muhammadu Buhari is actually serving his tenure. And so
this is his tenure now. Like,
it's supposed to be his tenure. So seem to be suggesting that he should be the one to be sworn in as president. Something like that.
Yeah.
When you hear such matters.
And that is where the commercialization of the entire process comes in. And that is why I get very worried that even the bar, and of course this is with very big respect to the bar, they need to also find a way. It is not just about trying to etch out the living, but of course it is also about corporate social responsibility and also finding ways to provide the clear precedents and advisories that help your clientele to understand very clearly that, look, these are, I mean, when you see some of the petitions and you go through the grounds, you just ask yourself, why do you have to bother yourself in all of these processes? And of course, like I said, of the 5 petitions in the presidential, I think the only one that came out very clear for me was the 25% FCT interpretation that we'll be seeking for, just to get that clarity. But of course, one seeking for the issue of drug addiction and cartel. One is asking for falsification of age, and that on that ground the election should be. These are issues that previous courts have actually tried. Okay, so like I said, there should be some kind of a minimal commercialization and politicization of the entire process. And a lot of people have also seen the process as a negotiation tool, to be able to use it as a yardstick to be able to now negotiate some level of relevance and influence in the governance of that is actually coming up. So there has been precedent in the past, and that is the challenge.
So
all right,
we have seen the pre-election matters in court and how they played out before the general elections and even after the general elections, where some people had to, wait for the outcome of what happens, who will be qualified to vie for particular positions. We saw how that played out. Prior to when Hope Uzodinma was declared as the governor of Imo State, I think a lot of Nigerians didn't believe that if you go to the court, you would get justice when it comes to election matters. Would you attribute that to, we're being very aware of the situation? And secondly, how do you think that this 1,044 cases will play out in court? Do you believe that the judiciary can deliver or be the last hope of the common man?
Yeah, I mean, most fundamentally is that it is going to strain the issue of schedule and timing. So the concern would be around meeting with the constitutional provision or the Electoral Act provision that says within 6 months that you must conclude this entire process. And of course also is about the disposal of the bench to some of those cases. Sometimes the attitude of judges sometimes suggests that they handle some of these things with some level of laxity, and then of course kept dragging, and of course the prosecutors, the lawyers who are also, so there are a lot of stakeholders in this entire process who will determine whether or not this process should go within scheduled time. Because I tell you, some cases shouldn't just last 3 to 7 days, they should be trashed out.
Okay, well, just hold on your thoughts. We'll be connecting back to Sam Kabul, who is now joining us via phone. If you can hear me, Sam Kabul, you can just proceed with your thoughts earlier on. We are looking at this as, is it a merit to our democracy or a demerit, really? Is it a product of, a strength of our democracy now that we have more people in courts, or is it an indication of the flaws in the process?
Well, I would say it's part of the process. due process is embedded in our own democratic process. It's also an aspect of the rule of law. Whoever is aggrieved, the courts and the tribunals are always there to hear you out. And for political cases, as we are developing both mentally and most times we tend so much towards our emotions than the reality. Just like the gentleman said, most of the cases that have been filed, most of the petitions that have been filed, they are ill-advised because they would not see the light of day. And I don't so much blame the litigants. I would think that the elites contributed a lot to this, and that has to do with the way they characterize the election after the elections. So much of a misinterpretation of the process and what constitutes valid elections were thrown out there, so much so that people mistook for ideals for reality. I have seen many election petitions. I've been to Kebbi and in Sokoto dealing with elections. And most of the grievances, most of the petitions are hammering on post-election matters, like non-posting of results to their areas and all of that. And many of them, too, they are bringing in things that we are supposed to have been dealt with for the elections, what they call pre-elections. So at the end of the day, you have a mix of everything. Of course, some of them have very good grounds, and if they have the evidence for those grounds, they could win. But I can tell you, if the Constitution says all matters must be heard on the merit, and if you have objections, those objections will be taken along with.
Okay, Mr. Sam. Okay, Mr. Sam, isn't it why we have lawyers that will guide the petitioners in this instance to tell them, what will hold sway and what will not? I mean, do you think that lawyers are actually playing that role of guiding, their clients appropriately, so that we don't end up wasting the time of the courts?
Well, you see, election matters are emotional, and for somebody who has spent a lot in the election, there is always that feeling that his luck would come at the tribunal. And most of them, too, sorry to say, believe that you just take the matter to the tribunal, they will get away with the tribunal. And that fully is playing a lot of parts. So to give their opinion to say, I do not think you have a case here. But they will tell you, don't worry, just file the matter, and we'll see how it goes. That's part of our nature. It's difficult for you to advise somebody out of a fight when he's already wearing his gloves, to do the thing. But if you ask me, honestly speaking, like I said, it's not that the Constitution says all matters must be heard to the end. More than 3/4 of these cases will not pass through the initial stages because they do not have evidence.
But can
like really... the gentleman.
Okay.
Okay, let me come to Salahuddin. Can we really absolve INEC from some of these issues? So if you look at this issue that we're looking about, over 883 petitions were filed on the grounds of non-compliance with the process, with the electoral process. So can we really just absolve INEC, from some of these things that are happening?
Yeah, like I said, that institutions like INEC, I must say, with every sense of modesty, is one of the most reformed government institutions since we have returned to democracy. In terms of processes, procedure, institutionalization, innovations, and putting some kind of... INEC has actually, to be very honest, emerged as one of the strongest agency of government Of course, also not without some internal challenges that we can reference as a gap in terms of capability to handle situations sometimes. And I think one of the biggest outcome from this election, basically, if you ask me, is not about process, it is about communication. There was some level of communication gap from the side of INEC. Maybe they didn't think it was necessary, or maybe because they felt that they took it for granted. But I think there was some level of communication challenge in the entire process. The third one is the fact that, yes, for every institutions, you always sometimes would come under fire. And like the learned friend had mentioned, the issue of election is about emotions. And you know too well that when you are emotionally upset about specific procedure, then of course it blinds your sense of reasoning. Then of course you see every other thing as being marshaled against you. And then of course there are these kind of perception that INEC is actually an agency of the state. And people don't also know too well that governors of ruling parties have been sacked by INEC in the past, and we have seen some of those instances also. And the fact is this also, that the court is not actually swayed by emotions. The court is actually swayed by the prima facie that you present before it. Those are the determinants, those are the ingredients that actually influences decisions eventually. But when people go to court with emotional petitions, then of course they are actually thrown out, and then of course they come back with this agitation that look it is because they already have some level of bias. But I think the fact is very clear that INEC has its own guide and rules that they have set, and those guide and rules may not have been followed completely. In some cases the court would definitely have to interpret the issue of non-compliance. Yes, they are the umpire. You cannot take away the fact that whatever happens in the electoral processes entirely actually sits on the board and the table of INEC, so you cannot absolve them entirely from the entire conversation. But the question would be that depending on which side of the divide you actually seated from. If you are seated from the side of those who actually have won, and then of course you clap for INEC and say, look, they have actually done well in the entire process, and that nothing had happened on the contrary. But of course, if you are on the losing side, then it is very easy for you to say, look, that things are not going your way. So, and that also tells you the absence of ideology in our entire political value chain. Because if you see ideals missing, it tells you very clearly that people would only be coming from the angle of self preservations and what actually resonates with them. But of course, like we said, matters are in court. The court would determine based on the ingredient and the validity of what actually has been presented to them.
Okay, let's get back to our legal guest, Mr. Kabul. You know, the CJN on countless occasions have reiterated how the judiciary has been burdened with a lot of cases. I think the last statistics stood at over 2,000 pending cases to be dealt with by the judiciary. And now we have these election cases. It's interesting that you said that some of these cases lack local standard or lack merit and will be struck out and might not even see the light of the day. But it still remains the fact that, you know, we have petition cases, and judiciary reporters will tell you how it is not really interesting to stay in court from beginning to end. And we're about to witness that era. So now the question is, what happens to all of the pending cases? Will this election tribunal right now that we're about to witness, or we're already witnessing, actually overshadow some of these cases? How do the judiciary now strike a balance?
It's difficult to strike a balance because they are understaffed, overburdened, and just like you said, you are adding another infernal burden on them. The cases that you talk about, they'll be languishing there in the dockets of the court. They would not be attended to until these gentlemen are back to the courts after the 6 months of the tribunal. And that is why many of us have said that we should try to establish special courts to handle trial matters. The entire court system, the entire judicial system is fully bogged down by political litigation, both before, after, before the election, you have the election matters. There are as many hours, if not more than, about now. And all of that then have to be given a kind of preference over other matters. So much so that even criminal matters, even fundamental human rights matters, and other matters that require urgent treatment, they are all put at bay because of what? Political matters. And we cannot, for the sake of our life, and for the sake of our democracy, and for our social health, continue like this. It's really against the grains of fair hearing and even justice for you to have a case that is supposed to be attended to, say, within a few months, lasting in court for years. And many times, before the cases are concluded, some of the parties would have died. And I do not see justification for the giving of preference political over the other districts. It's a district because what? Politics is a career for others. As much as they earn their living for it, so also others are dependent on their career. Now we have what? Dedicated the entire judicial system towards the resolution of cases. And like the gentleman is talking about, people understand that INEC is not expected to conduct election foolproof. What the law requires is what? Substantial.
Okay.
And if you ask me, if we are talking about the problem of service delivery as the brain of our development, INEC is one of the institutions that you could be proud of.
Okay.
And yet, people have all sorts of misgivings as to how elections are to be conducted, so that matters that don't really touch only the actual voting and the declaration of the winners are being taken to the tribunal.
Okay, Sam. Okay, Mr. Sam. Okay, yes. Mr. Sam, because of time, I have to just interject here at this point. There's a phrase that have become like a cliche in the aftermath of these 2023 general elections. Go to court. If you are not happy with the process, go to court. And it's almost as if there's nothing that INEC can do within the process to make sure that people do not necessarily have to go to court. So, for instance, we've seen situations where it's like there's a deliberate plan to just get to the point of declaring the results and allow whatever that will follow to the court. So in the Adamawa case is a very good example in this instance. And for some people, it is like saying, well, we know our way around the courts. And it seems, or it appears as though the courts seem to have lost its, I would say, credibility. There's some kind of dent on the courts, because others will say, well, if our courts are really up and doing, people would be scared to say, let's go to court, even when they know that they are not, on the right path, or when they know that they are perpetrating illegality and the rest of them. So how can we make sure that the judiciary reassert itself and kind of give people some confidence that, look, we will do justice?
I can tell you that the judiciary will do justice. And go to court is the language of INEC or that of the court, is that of politicians. Politicians have a way of annoying themselves, have a way of devaluing themselves or demarketing themselves or writing themselves. That should not in any way have declared our any matter. Let me tell you something. What happened in Adamawa is an aberration. INEC has responded to actually demonstrate the fact that that's a demonstration. It is not true that INEC would just musically declare results and ask parties to go to. No, even for us, for some of us, this issue of supplementary elections is by itself unnecessary. Let there be one day, one vote. If the people are obstructing an election, violence, let them face the consequences by what? No part of the next candidates. But when you indulge them, they obstruct election, and tomorrow you use back the resources of the states to placate them with another form of election. That's why you have this rampant obstruction elections all over them. Let INEC start putting its feet down and say, hey, politicians, if you do not put your acts together and you use violence, you would not be burdened with supplementaries. The court will do their job. Let me tell you something. 9 out of 10, the blades that go to the courts are blades that should have gone to the lawyers who are mismanaging or who, out of incompetence, mismanage the cases of their clients and turn around to blame it on the courts. The court system and the judicial process, especially the executive process, is a very delicate one. That is the basis of being a lawyer. That is the difference between you having a degree of a law degree and a practitioner.
Okay.
It's a very serious, serious thought and focus.
Okay.
All right.
Thank
you.
You lose the courts have compromised. Compromise what? Your evidence is your evidence compromised?
All right, thank you so much, Mr. Sam Kabos. Unfortunately, we cannot proceed because of time constraint here, but we do appreciate your thoughts and perspectives on Daybreak this morning. And thank you so much, Salahuddin Hashim, former Senior Program Officer at CISLAG and also currently the Director of Programs, Clean Foundation. Our guest, Sam Kabos, a legal practitioner who joins us from Sokoto. We do appreciate you.
Thank you very much.
Thank you for coming.
Thank you.